Good day, Crime Talk aficionados. We have a great show for you today. First, some significant court orders dropped late last night in the Bryan Kohberger case. We have an update on the Karen Reed matter. We have to watch out for that one party mom at every grade school. A Post-it spurs an investigation of child abuse. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for watching. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. Now, before we get to this great show today, let me remind you to go to crimetalksearch.com and sign up for that background subscription service today. When you do, you'll be able to do as many background searches on anyone here in the United States that you desire. You're going to get a report literally prepared while you wait, and then it's going to be emailed to you, and you can even opt in to get updates. And in the report, you're going to get information regarding the person that you're searching, telephone numbers associated with them, emails associated with them, social media associated with them. Now, you may say, why do I need to know all this? Well, let's say you're dating somebody and they have one email address that they give to you, and you find out that he has 5 other email addresses for all his other dating sites that he's on. You probably want to go check that out. Well, you're also going to get information in there regarding criminal history. Is somebody on a sex offender registry? Are they married? Are they divorced? Do they have liens or judgments? So go to crimetalksearch.com and find out. You're going to be happy that you did. All right, let's go ahead and open the record for Friday, April 25th, 2025. And as I said in the intro, ladies and gentlemen, some significant court rulings have come down in the Bryan Kohberger matter. They came down late last night. Now, as I have told you before, these are all the, hold on, I'm getting it here. These are all the motions. Let me take out that legal pad there. These are all the motions that have been filed in the Kohberger matter in the last month or so. And we've gone through everything, so you don't necessarily have to do it all yourself. Now, I keep that there because I want to make sure I have them handy when I reference them if something comes up, and I want to be able to make sure I have it. And I have even a bigger pile over here. I know, I need to put it in a filing system, but it's so much easier to access when you have paper. I'm an old school paper guy. I like paper. Anyway, so let's get to it. As we have tried to do with the Kohberger matter, because there's so much information out there that is basically false, and a lot of the information that we would all like to know has been, well, sealed, and we don't get a copy of it. But the court record is by far the best, and the court orders and the motions are the best way to find out what new information is out there. So let's begin. This is the order on the state's motion in limine regarding the text messages and 911 calls. Now remember, the motions that we went through, these are the text messages of the surviving roommates that night, and the defense wants to keep them out. Of course they do. And the prosecution wants to bring them in. Of course they do. So let's get to it. Like I said, order on state's motions in limine regarding the text message. And this hit late yesterday afternoon on April 24th, 2025. So let's begin. Introduction. DM and BF are 2 surviving roommates at 1122 King Road. At the time of the homicides were believed to have occurred. DM saw a masked intruder in the house and began calling and texting other roommates, including BF. Approximately 8 hours after DM saw the intruder, BF called 911 from her phone. Before the court is the state's motion to allow the text messages by DM and BF. Testimony about their conversations with each other about what DM saw and the 911 call. The state argues these communications are either not hearsay or qualify under one of the more exceptions to the hearsay rule. It also asks that a transcript of the 911 call be provided to the jury to view while listening to the audio. Defendants challenged several of the communications and objects to the use of the transcript. Oral argument on the motion was held on April 9th of 2025, after which the court took the matter under advisement. The court finds that some of the hearsay statements on the 911 call do not qualify qualify under the exceptions cited by the state and therefore must be redacted. However, the balance of the 911 call, as well as the texts and conversations noted herein, are likely admissible provided that the requisite foundation is laid at trial. And then the footnote, the court's ruling on the specific text messages, phone activity, and 911 call statements are appended hereto in the table format as Exhibit A and B, respectively. The transcript will be allowed as a demonstrative aid, again, assuming the proper foundation is established. And that's a sign of a good trial judge. He's going to say, you know, this is a trial issue. We're not going to rule on all of this pre-trial. Let's see if the prosecution can meet their burden and provide the evidentiary foundation that's necessary. Next, the standard. Whether a statement falls within the present sense impression and or excited utterance exception is a question that is left to the sound discretion of the trial court, given consideration to the totality of the circumstances. Use of demonstrative aids is also a discretionary determination, and on discretionary matters, the trial court, 1, must correctly perceive the issue as one of discretion. 2, act within the outer boundaries of its discretion. 3, act consistently with the legal standard applicable to the specific choice available to it. And 4, reach its decision by exercise of reason. Number 3, facts. And there is a footnote here. The parties submitted various portions of the grand jury transcript as different exhibits, including the state's exhibit S1 to the 911 call motion, defendant's exhibit 1 to the objection to the 911 call motion, and the state's exhibit S21 and S3 to the text message motions. To avoid confusion, the court will cite to the grand jury transcript rather than cite to the individual exhibits. Citations to DM and BF's phone activity in bubble format attached as Exhibit 1 and 2 respectively to the defendant's objection to the state's text message motion will be referenced as D1 and D2. Next, after spending the evening out, roommates DM, BF, and Kaylee Gonzalez and Madison Mogan returned to their home at 1122 King Road in the early morning hours of November 13th, 2022. At approximately 2 a.m., they met up in Kaylee's bedroom and talked for a while before going to bed. The fifth roommate, Zaina Kernodle, who was out with her boyfriend, Ethan Chapin, was not home yet. The roommates debated going out to a food truck for a late snack, prompting DM to send a text at 2:10 a.m. to an Uber driver she knew to see if he was driving, Exhibit D1. Ultimately, however, the girls decided to just go to bed. At approximately 4 a.m., DM heard strange noises and crying coming from the bathroom. She opened her door at one point and saw a man dressed in black with a ski mask and walking by her bedroom door. She then placed calls and texts to her other roommates to see if they were awake. Only BF, who resided on the ground floor, answered. They spoke once for 24 seconds, during which DM and told BF she thought she heard something. They spoke again a minute later for 41 seconds when DM told BF she saw a man in a ski mask leaving the house. Footnote, BF testified to her recollection of the content of the two phone calls before the grand jury. However, DM could not recall specifics about what was said, and he cites the grand jury transcript. They exchanged the following text messages between 4:22 and 4:26 a.m. DM to BF. No one is answering. DM to BF. I'm really confused right now. DM to Kaylee. Kaylee, DM to BF. What's going on? BF to DM. Yeah, dude, WTF. BF to DM. Zaina was wearing all black. DM to BF. I'm freaking out right now. DM to BF. No, it's like a ski mask almost. BF to DM. STFU. Shut the F up is what that stands for. BF to DM. Actually, DM to BF. Like he had something over his head and and mouth. DM to BF. Bethan, I'm not kidding. 0M so freaked out. There's some typos in there. BF to DM. So am I. DM to BF. My phone is going to die. BF to DM. Come to my room. BF to DM. Run. BF to DM. Down here. DM to BF. I'm scared, though. BF to DM. Yeah, I know, but it's better than being alone. Exhibit D1. There's a footnote. The typos and abbreviations are in the original messages. Next, during the following exchange, DM also attempted contacting Ethan Chapin through Snapchat. That was referenced in the grand jury transcript. DM testified before the grand jury that Instagram is a text messaging app that is used by young adults to communicate. She again tried calling Kaylee and Zaina, but neither responded. DM then exited her room and began running towards BF's bedroom. On her way, she noticed Zaina lying on the floor of her bedroom with her head towards the wall and her feet towards the door. DM thought Zaina was drunk, referring to the grand jury transcript. Once DM arrived at BF's room, they locked the door and both made additional unanswered calls to other roommates. At 4:32 a.m., DM again texted Kaylee, "Please answer," with no response. Between approximately 5 a.m. and 6:30 a.m., DM engaged in activity on her phone, primarily creating, editing, and deleting images and videos. Her phone activity then ceased until 8:05, when DM accessed Instagram for a few minutes. At 10 a.m., DM again accessed Instagram and communicated over Snapchat. At 10:23, she texted Madison asking, "Are you up?" She received no response. DM continued to access Instagram and Snapchat until 11:29 a.m. when she texted Kaylee, "Are you up?" Again, there was no response, which DM thought was strange because Kaylee and Madison were early wakers. DM continued accessing various social media sites, including checking Ethan and Zaina's Snapchat location. At approximately 11:40, DM's father texted her about scheduling a time for a chat, to which DM responded. She also received 2 texts from a person named Jenna stating, "Bro, and do you guys need me to come get you?" At approximately 11:50 a.m., DM called her friend EA and asked her to come over and check the house because she was scared. EA and her boyfriend HJ, they met DM and BF at the bottom floor of the house. Together, DM, BF, and HJ started to walk up the stairs to the second floor. When they reached the second floor, HJ went to the kitchen to grab a kitchen knife. When he came back out, he saw Zaina again for a split second. And I just started bawling because I thought she had just I don't even know. I thought maybe she was still drunk and asleep on the floor. BF also saw Zaina lying on the floor. HJ told DM and BF to get out. EA had started up the stairs, also turned around after HJ instructed her not to come any further. They both went outside. Shortly afterwards, HJ exited the house and told them to call 911. He was pale white and mentioned something about someone being unconscious. At 11:56 a.m., BF called 911 from her cell phone and spoke to Caroline Calvin, the 911 dispatcher. The call lasted 4 minutes and 11 seconds. During the call, the phone was passed around to different individuals, including BF, DM, HJ, and an unidentified female speaker. Heaving, heavy breathing, and crying can be heard throughout the call. BF spoke first, stating, "Something is happening. Something's happened in our house, and we don't know what." BF attempted to provide the address of the house to dispatch, but could not continue. At that point, an unidentified female speaker took the phone and provided the address and BF's phone number. The following exchange occurred. 911 operator: "Okay, tell me exactly what's going on." Female: One of our roommates who's passed out and she's drunk last night and she's not waking up." 911 operator: "Okay." Female: "Oh, and they saw some man in their house last night." "Yeah." 911 operator: "Are you with the patient?" DM: "Hi, this is DM." 911 operator: "Okay, I need someone to keep the phone. Stop passing it around." DM: "Can I just tell you what happened pretty much?" 911 operator: "What is going on currently? Is someone passed out right now?" DM: "I don't know, but pretty much at 4 a.m. 911 operator: "Okay, I need to know what's going on right now. If someone is passed out, can you find that out?" DM: "Yeah, I'll come. Come on, B, we got to go check. But we have to. Is she passed out?" "She's passed out. What's wrong? She's not waking up." HJ: "Zaina." DM then informed dispatch that Zaina was 20 years old. At that point, HJ took the phone. Dispatch asked him if she was breathing, to which HJ answered no. Law enforcement arrived at this point after confirming with DM that the responding officer had a defibrillator. Dispatch ended the call. Later, at approximately 1:04 p.m. that day, DM received a vandal alert regarding the homicide. Analysis. The state seeks to admit DM and BF's phone records from November 13th of 2022, including call records and text messages, as well as illicit testimony by DM and BF regarding their communications with each other on November 13th, 2022, that they testified to before the grand jury. The state also seeks to admit 911 call and the official transcript thereof. The state argues these records and communications are not hearsay, or they are exempt from hearsay as excited utterance or present sense impressions. Defendant objects, arguing that apart from HJ's statement to 911 that Zaina was not breathing, the exceptions do not apply to hearsay statements. The court finds that the bulk of the statements are likely admissible, with 3 exceptions of statements made during the 911 call. Hearsay is an out-of-court statement admitted to prove the truth of the matter asserted. And he cites Rule 801, the hearsay rule. To be hearsay, the statement must be intended as an assertion of fact and offered by the proponent for the purpose of proving the truth of the assertion. And he gives a citation. If a statement is hearsay, to be admitted, it must fall under an exception. Hearsay statements on a 911 call can typically be admitted into evidence under either the public records or business records exception to the hearsay rule. However, because citizens who call 911 are not under any duty to report, a recorded statement by a citizen must satisfy a separate hearsay exception. Typically, these exceptions include the present sense impression exception and the excited utterance exception. The present sense impression exception authorizes the admission of hearsay if it is a statement described or explaining an event or condition made while immediately after the declarant perceived it. The rationale justifying the exemption is that the immediacy of the statement offers no opportunity for fabrication. The rule recognizes that many, if not most, instances, precise contemporaneous is not possible, and hence a slight time lapse is allowed. In Kaiser, which is a case that is cited, the Idaho Supreme Court observed that time lapse as short as 45 minutes have been considered too long to invoke the protection of the exception. The excited utterance exception to the hearsay rule authorizes the admission of hearsay if the testimony recounts a statement related to a startling event or condition while the declarant was under the stress or excitement caused by the event or condition. To fall within the excited utterance exception, 1, there must be a startling event that renders inoperative the normal reflective thought process of the observer, and 2, the declarant's statement must be a spontaneous reaction to that rather than the result of reflective thought. In considering whether a statement meets the excited utterance requirement, the totality of these circumstances must be considered, including the amount of time that elapsed between the startling event and the statement, the nature of the condition or event, the age and condition of the declarant, the presence or absence of self-interest, and whether the statement was volunteered or made in response to a question. There is no bright line rule as to the allowable time span between the event and the statement, and one likely should not be drawn. As with the present sense impression exception, the rationale underlying the excited utterance exception is the special reliability which is regarded as furnished by the excitement suspending the declarant's powers of reflection and fabrication. Text messages and verbal conversations between DM and BF are likely admissible. As an initial matter, the court finds that DM and BF's acts of making phone calls, sending or receiving text messages, and other phone activity such as accessing social media are not hearsay. Hearsay only captures an oral assertion, written assertion, or nonverbal conduct intended as an assertion. Thus, this order will focus on the content of those calls and texts to the extent available. As to the content of DM and BF's text messages about what DM saw, the court finds that they are either not hearsay because they are not offered for the truth of the matter asserted, or not assertions, or if hearsay, they likely qualify as a present sense impression and or excited utterance as set forth in Exhibit A hereto. Their verbal discussions are potentially admissible for those same reasons. The state must establish the foundational requirements for such proffered statements at the time of trial. Number 1, DM texts Uber driver at 2:10 and 29 seconds to inquire if he is driving. The state seeks to introduce this text to establish a timeline, specifically to establish DM was awake and texting at 2:10 a.m. Defendant does not directly challenge the text because it is not offer of the truth of the matter asserted and or the assertion of facts the court finds it is not hearsay under 801. Number 2, text messages between 4:22 and 4:26 a.m. The state argues that the 4-minute series of text messages between DM and BF, with one from DM to Kaylee, are admissible as either present sense impressions or excited utterance. Defendants suggest neither exception applies because there is no evidence they were sufficiently startled by the events. He points out that DM claimed only to be confused, and despite stating she was scared, she ran to BF's room instead of leaving the house or otherwise calling other friends and family for help. The court agrees with the state for those texts qualify as an assertion. Several of the texts in this exchange are not assertions of fact, but rather inquiries and or commands incapable of being proved true or false. First, the present sense impression exception does not require a startling event. It simply requires that the speaker describe or explain a condition while personally perceiving it or immediately thereafter. Most of DM's texts to BF satisfy this exception. She first texts that no one is answering, which describes the result of her calls to her other roommates just before. She also states what she is immediately feeling, i.e. confused, freaked out, and scared. Her texts state that she was scared. Considering that the capital A is right next to the caps lock's key and E is right next to the W, it is evident she was likely texting quickly and accidentally mistyped scared over what she saw and heard and the facts that none of her roommates are answering. She further described the intruder she saw, i.e. wearing a ski mask or something over his forehead and mouth. She also relays that her phone is going to die. Thus, these statements are likely admissible as present sense impressions. In addition, the events are sufficiently startling to both DM and BF for purposes of the excited utterance exception. DM and BF are young female students, and the self-described scaredy cats of the house. They refer to the grand jury transcripts. They were awoken from a sleep after a night of drinking with DM, reporting that she heard noises and saw a masked intruder in their home. None of the other roommates were responding to their calls and texts, further indicating something was amiss. It would be potentially terrifying for anyone, including these young women, to argue that they would have run out of the house or called someone else for help had they really been startled. Unemphatically ignores these circumstances and the trauma and confusion they were evidently experiencing, which likely offsets logical thought. Footnote: defendant's argument also ignores the fact that DM indicated to BF that the intruder was leaving the house, in which case it is not surprising the girls did not want to run outside, or had that thought cross their minds at all. Indeed, the girls' fear and confusion is evident in their words, with both questioning what's going on. DM stating she was freaked out, scared, and confused, and BF attempting to get them together quickly for safety. They were clearly under stress and attempting to make sense of the frightening situation. Additionally, the time period that elapsed between what DM saw and her communications with BF about the same was a matter of minutes. The text message exchange lasts approximately 4 minutes, with the message occurring in rapid succession. This timeline left no time for the reflection or fabrication, which is ultimately what Rules of Evidence 8031 and 8032 seek to protect against. Consequently, the court concludes that the assertive text messages within this 4-minute period are likely admissible as present sense impressions and or excited utterance, assuming the requisite foundation is provided at the time of trial. Third, DM text messages to victims. At 4:32 and 57 seconds, DM texted Kaylee, "Please answer." The state argues this text is admissible as a present sense impression and an excited utterance. Defendant does not directly address the text. However, the court finds it is more of a command or a request than an assertion of fact, if it is not a fact capable of being proved true or false. Thus, it is not barred under Rules of Evidence 801. Even if it were an assertion, it would qualify as a present sense impression and or excited utterance. DM had just seen a masked man in her home minutes prior after hearing unusual noises, and none of her roommates other than BF are responding to her calls and texts. Her fear is evident in the words she uses. Please answer. It is less of a request or an assertion and more of a desperate plea made out of concern that something is wrong. Then, at 10:23, DM texts Madison, asking, "Are you up?" And approximately 1 hour later, DM texted Kaylee, "Are you up?" The state argues the foregoing texts are not hearsay because they will not be introduced for the truth of the matter asserted. Alternatively, the state contends they are present sense impressions because they represent a consistency and continuation of DM's text from the prior night. Defendant disputes that the exception applies, pointing out that DM had been awake and accessing social media before she sent the text. Again, the court does not find these texts to be assertions. They are inquiries, not declarative statements. Even if they were assertions, however, if the state intends to admit these statements to establish a timeline of events, they are not hearsay because they are not offered to establish their truth. Therefore, they are not barred under Rules of Evidence 801. 5. DM calls and texts to and from others. The state contends that the texts between DM and her dad, the texts from JM and the vandal alert are not hearsay because they will be offered simply to show a timeline for the morning and early afternoon. In addition, the state notes that the phone calls from DM to EA is not a statement and therefore not hearsay. Footnote, the state does not address the context of the phone call. However, court finds it likely qualifies as a present sense impression. DM testified she asked EA to come over and check on the house because she was scared. She is describing her fear at the time she is experiencing it. Beyond that, the specifics of what was said regarding what DM saw hours prior will have to be analyzed at the time of trial. The court agrees and will allow the evidence for the purpose of a timeline if the requisite foundation is laid. B. Verbal communications between BF and DM. The state next contends that it intends to ask DM and BF at trial about statements they made to each other on November 13th of 2022. It argues the testimony will likely replicate that provided by the witnesses at the grand jury proceedings. The state contends they are admissible under the present sense impression and or excited utterance exceptions, and defendant does not directly address the argument. To the extent DM and BF seek to testify about the content of the calls, texts, and conversations about what they perceived during the 4:30 timeframe, they could be potentially admissible under the exception cited by the state. However, the state must establish the foundational requirements for such proffered statements. The grand jury testimony does not appear to include any conversations between them after 4:19 a.m. to 4:37 a.m. timeframe, and the state has not pointed any out. Thus, to the extent they testify to oral conversations they had after they woke up the next morning, the court will reserve ruling and consider any hearsay objections at the time. Next, the 911 call. The state contends that the entirety of the 911 call should be admitted because the statements therein are not hearsay, i.e., not admitted for the truth of the matter asserted, or they are accepted from the hearsay rule as present sense impressions and or excited utterance. Defendants generally objects to the admission, but takes particular issue with 3 statements within the call. The court finds the defendant's objections to these specific 3 statements well placed, but it will allow the balance of the call because the statements are either not assertions, not admitted for the truth, and or they are accepted from the rule set forth in Exhibit B attached hereto. Footnote 11. Portions of the call may qualify under Rules of Evidence 8034, statements for purpose of medical treatment or diagnosis. Because the parties have not argued this exception applies, the court will reserve ruling on its pending foundation being laid and an opportunity to brief and argue its applicability. Initial statements. The 911 call begins with BF telling dispatch, something is happening. Something's happened in our house and we don't know what. The statement falls squarely within the present sense impression exception, given that BF was experiencing concern that something was wrong with their roommates, and HJ had just instructed her to call 911 after walking through the house. Thereafter, BF attempts to provide dispatch with the address of the house before an unidentified female speaker takes the phone and provides the address and BF's phone number. This exchange is not offered for the truth of the matter asserted and therefore not barred by the hearsay rule. Number 2, female. One of our roommates was passed out and she was drunk last night and she's not waking up. The state argues this statement is a present sense impression because the female speaker is describing the scene around her. However, as defendant points out, the roommate at issue in the statement is Zaina. The only individual who experienced or saw Zaina unresponsive were DM BF, and HJ. Thus, defendant contends the exception does not apply because the female speaker never saw Zaina unresponsive and thus lacks firsthand knowledge of the information contained in the statement. The inquiry here turns on whether the event the female speaker is describing or explaining is that Zaina is unresponsive, as defendant contends, or whether it is more generally the scene unfolding at the house, i.e. that her friend saw Zaina unresponsive. The female speaker did not personally perceive the former, but she did personally perceive the latter. When the words themselves are considered, it is clear that the event being described is that Zaina is unresponsive, not that the speaker's friend saw Zaina unresponsive. In other words, she is relaying to 911 what her friends observed and related to her. Her statement is, therefore, outside her present sense impression, and thus the statement is not admissible under that exception. Next statement. Female. Oh, and they saw some man in their house last night. Yeah. The state argues this statement is both present sense impression and an excited utterance because it is in response to finding Zaina unresponsive. Defendant responds that the statement references an event DM saw 8 hours prior to the 911 call and therefore is not contemporaneous. Defendant also points out that the female speaker does not have personal knowledge and is simply repeating what she was told by others. The court agrees that the present sense impression exception does not apply to the statement because the speaker is recounting what somebody else perceived. Additionally, there is no contemporaneous since she is describing an event that occurred hours earlier. The excited utterance exception does not apply here either. Instructive here is State v. Fox, where to Idaho Supreme Court considered whether the excited utterance exception applied to a 911 call made by a man after he found a woman screaming for help for her friend who she said had just been pistol whipped by a man who fled the scene. The 911 caller had not seen what happened, but relayed to dispatch what the victim told him about the incident. The court held that the district court erred by admitting the 911 caller's statement to dispatch as an excited utterance because the caller's voice was calm and he had not experienced the start of an event or condition. Here, likewise, the audio of the 911 call does not indicate that the speaker's normal reflective thought process were rendered inoperative. Her voice sounds calm relative to BFs and DMs. Although a slight nervousness can be detected in her voice, she is not audibly crying or breathing heavily. In fact, the speaker took over speaking to dispatch because she was more composed than BF, who initiated the call. Further, the speaker did not personally see Zaina unresponsive, nor did she see the man allegedly in the house. She is simply repeating what others told her, so the statements do not provide insight into her thought process. Consequently, the statement must be redacted. Number 4, DM's attempt to explain events. After the female speaker cedes the phone to DM, DM identifies herself and asks if she can tell dispatch what happened. Dispatch responds by asking what is going on and if someone is passed out. The exchange will not be offered for the truth of the matter asserted and therefore is not hearsay. However, DM then states, I don't really know, but pretty much at 4 a.m., the state argues that this statement is a present sense impression and or excited utterance because DM is trying to explain to the dispatcher what she saw while under the current excitement and realizing that her roommate is not waking up and something could be wrong in the house. Defendant disagrees, noting the event DM begins to describe what occurred 8 hours prior. He further argues it is not an excited utterance because she and BF had several hours to reflect on what she had seen and experienced at 4 a.m. Defendant is correct that the statement does not qualify as a present sense impression. While DM personally perceived the event she is beginning to describe, the contemporaneous aspect is missing. She is attempting to narrate an event that she saw 8 hours earlier. The excited utterance exception doesn't apply here. While DM is no doubt under the stress and the excitement caused by realizing Zaina is unresponsive, her reflexive thought process appears intact. She is starting to draw connections between Zaina being unresponsive and what she saw and heard 8 hours prior, something that she had time to reflect upon. She does not launch spontaneously into what she saw at 4 a.m. Rather, she asks the dispatcher if she can explain what she saw. Based on this exchange, it is clear her powers of reflection are quite active, thus obviating the purpose behind the exception. The statement, therefore, is not admissible and must be redacted. Statement regarding Zaina. Dispatch then instructs DM to find out if someone is passed out. DM appears to make statements to bystanders that they have to go check if Zaina is passed out. This is not offered by the state for the truth of the matter asserted and therefore not hearsay. DM then states that Zaina is not waking up. HJ is heard stating Zaina is in the background. These are squarely present sense impressions because they are describing what the speakers are seeing. Footnote 13. In addition, the statement that Zaina is not waking up is potentially admissible under 803.4. That's the medical diagnosis exception. These are squarely present sense impressions because they are describing what the speakers are seeing. DM then responds to dispatch inquiries about Zaina's age, again not offered for the truth of the matter asserted, before HJ takes the phone and confirms that Zaina is not breathing. This is also a present sense impression and also likely falls within 803.4. Statements after law enforcement arrived. Around the time HJ confirmed to dispatch that Zaina was not breathing, law enforcement had arrived on the scene. HJ can be heard telling DM, I need you to talk to them. I can't talk to them. I need you to talk to them. The court finds this admissible as either a present sense impression or excited utterance. HJ had just discovered Zaina's body moments before. He is operating under the stress of his discovery and attempting to answer dispatch questions. His statements described his inability to speak to law enforcement at that moment and therefore are admissible. At that point, DM took the phone again, and dispatch instructed her to get a defibrillator if one is available. DM asked dispatch to repeat the question and stated, there's a police here right now. After dispatch repeated the question, DM indicated that they did not have a defibrillator and asked if the responding officer if he did. The responding officer affirmatively, after which dispatch indicated she was going to let the officer take over and end the call. To the extent the state seeks to admit these statements by DM for their truth, they qualify as present sense impressions as DM is explaining the events as they are happening. They are also likely admissible under 803.4 insofar as they regard the defibrillator. Finally, many of the statements are not assertions and thus not hearsay. Next, crying, breathing, heaving is not hearsay. Apart from statements, the state also moves for admission of the audible crying, breathing, and heaving made by the 911 callers. The defendant does not address the argument, and the court finds it is well placed. While assertive conduct can qualify as hearsay, non-assertive conduct does not. There is no indication in the 911 call that the speakers are intending to make an assertion through their crying and heavy breathing. It is clearly an involuntary emotional response to the circumstances. Further, it is relevant to show the stress and emotional impact the girls are under, which puts the call into context. Thus, it is admissible. Next, a transcript of the 911 call will be allowed as demonstrative evidence. The final issue is whether to allow the jury to view the official transcript of the 911 call while listening to the call. The defendant contends it would be cumulative and asks that either the call or the transcript be allowed, but not both. The court views this issue as essentially a request for use of the transcript as a demonstrative aid. The demonstrative exhibit is relevant if it supplements the testimony of the witness or assists the jury in obtaining a better understanding of the facts. Transcripts are widely used as demonstrative aids to help the jury understand the context of audio recordings. When used this way, courts will typically instruct the jury that the transcript is not evidence independent of the audio recording, and if the jury determines that the transcript is incorrect, it should disregard it to the extent and rely on its own interpretation of the audio recording. In addition, the transcript must be authenticated by showing that it is fully and accurately complies with the audio recording. Footnote 14. This may well require the transcriptionist to testify that he or she accurately transcribed the call. Against this background, the court will permit a transcript of the 911 call to be used as a demonstrative aid, assuming the proper foundation for the 911 call is established and the transcript is properly authenticated. Footnote 15. Rather than passing out individual copies of the transcripts to each juror, it may be best to time the audio with the text of the transcript and play that for the jury with the closed captioning. Otherwise, there is a concern the jury will read ahead or focus too much on one portion of the transcript and not another. However, the actual audio exhibit without the captioning is one that will go back to the jury. To this end, the state is responsible for proposing an appropriate jury instruction. The transcript will not be admitted as substantive evidence and will not be available to the jury except when the 911 call is being played, including during deliberations. Because it is not going to be used as evidence, the court does not find the transcript is cumulative to the 911 audio or otherwise prejudice the defendant. Order. Based upon the foregoing, the state's motion in limine text messages and testimony is granted in part, reserved in part. The state's motion in limine regarding the 911 call is granted in part, denied in part, and reserved in part. Then the court attaches the text messages and phone activity. I'm not going to go through the transcripts because I believe the applicable statements that the court ruled upon are appropriate. Frankly, I think the court got it correct. Present sense impression, clearly not hearsay. Excited utterance, I'm not a big fan of excited utterance, particularly when people have time to pause and reflect. But I understand the court's ruling in this particular matter, and I think the court got it right. Where somebody on the call has no personal knowledge of something, but is simply testifying to what somebody else said to them. Classic hearsay. The court got that one correct as well. Next, the big order. Order on defendant's motion to strike the death penalty regarding the autism spectrum disorder. We spent a lot of time on this. This is going to be interesting, ladies and gentlemen. Let's go. This was dated April 24th, 2025, and it was filed at 3/17 on that same day. Introduction. Having been recently diagnosed with autism spectrum disorder by a clinical neuropsychologist retained by the defense team, defendant seeks to strike the death penalty as a sentencing option, arguing it violates his constitutional right. He contends that ASD is the functional equivalent of an intellectual disability, which is categorically recognized as a disqualifying exemption to the death penalty. Even if the court rejects a categorical approach, he argues the death penalty option should nevertheless be stricken in his case, given the intense media attention on defendant's disability. In response, the state disputes that ASD is equivalent to an intellectual disability for purposes of categorical exemption to the death penalty, and further notes that the defendant has not shown a national consensus supporting such an exemption. As for defendant's individualized argument, the state contends that none of the defendant's concern warrant striking the death penalty. Oral argument on this motion was held on April 9th of 2025, after which the court took the matter under advisement. The court finds striking the death penalty is not warranted. Next, standard. Constitutional issues, including the constitutionality of Idaho's capital sentencing scheme, are questions of law. Facts. During the course of this case, the defense team retained Dr. Rachel Orr, a clinical neuropsychologist, to conduct a comprehensive neuropsychological evaluation of defendant and issue a report. And that's Defendant's Exhibit 2, which is referred to as the Orr Report. As part of this evaluation, Dr. Orr interviewed defendant's immediate family members, and other relevant adults from the defendant's childhood, including former teachers. She gathered information on defendant's history, made behavioral observations, and administered cognitive tests. Based upon her evaluation, Dr. Orr diagnosed defendant with autism spectrum disorder level 1 without accompanying intellectual or language impairment. According to Dr. Orr, ASD is a complex, heterogeneous neurodevelopmental disorder rooted in brain differences and characterized by social and behavioral features. It causes deficits in which affected individuals perceive and react to others and their environment, causing problems in social communications and interactions, repetitive behaviors, and narrow range of interests. Footnote number 1, Dr. Eileen Ryan conducted a psychiatric evaluation of the defendant and agreed with Dr. Orr's diagnosis. Her expert report is attached to her disclosures filed by the defendant's Exhibit D13 on January 13th of 2025. There's a wide range of autism symptoms and severity. Deficits can include a restricted range of effect, atypical eye contact, displaying facial expressions or movements that do not match what is being said, failure to consider social cues, having trouble with speech reciprocity, and repetitive behaviors. Once again, footnote number 2 cites to the U.S. National Institute of Mental Health website, and then it gives a link to that. Pursuant to the American Psychiatric Association's Diagnostic and Statistical Manual, 5th edition, 2013, known as the DSM-5, there are two primary diagnostic criteria for ASD. U.S. Center for Disease Control and Prevention is cited. The first criterion is persistent deficits in each of the following areas of social communications and interactions. 1. Social emotional reciprocity. 2. Nonverbal communicative behavior used for social interactions. And 3. Developing, maintaining, and understanding relationships. The second criterion is the display of restrictive, repetitive patterns of behavior, interests, or activities as manifested by at least two of the following. 1. Stereotyped or repetitive movements, use of objects or speech. 2. Instances of sameness, inflexible adherence to routines, or ritualized patterns of verbal and nonverbal behavior. Highly restricted, fixated interests that are abnormal in intensity or focus. And 4. Hyper or hypo-reactivity to sensory input or unusual interest in sensory aspects of the environment. The severity of ASD is based on these two criteria. There are 3 levels of severity which correlate to how much support is needed. Level 3, which is the most severe, requires very substantial support. Level 1, the least severe, requires merely support. As to the first criterion, Dr. Orr noted that in her report, the defendant's family and peers reported the defendant displays atypicalities and difficulties in social settings dating back to early childhood. Footnote number 3. At an early age, defendant's school psychologist recommended that he be evaluated for ADHD and Asperger's disorder, now ASD, and he was clinically diagnosed with only ADHD. As to the first criterion, defendant Orr noted the defendant's family and peers reported the defendants displayed atypicalities and difficulties in the social setting dating back to early childhood. Then I read the footnote, and then including number 1, inability to adjust his behavior to suit social context. 2, poor social reciprocity in conversations. 3, issues with nonverbal behavior like personal space. And 4, limited ability to take perspectives of others. She notes that these difficulties played a role in the eventual termination of his funding for his graduate program. At the time of his arrest, he was pursuing a PhD in criminal justice and criminology at Washington State University. Footnote 4. Defendants previously received an associate's degree in liberal arts with a concentration in psychology in 2018, a bachelor's degree in forensic track psychology 2020, and a master's degree in criminal justice in 2022. Defendant achieved a 4.0 GPA in his master's program. In her personal evaluation of defendant, Dr. Orr observed that defendant demonstrated some typical social behaviors such as fairly consistent, though intense, eye contact, polite demeanor, and social conventions, for example, shaking hands upon greeting. He engaged in conversation and was never overtly inappropriate. However, Dr. Orr also noted social behavior consistent with that report by others, such as a lack of fluidity in his verbal interactions, awkward comments. Footnote, by way of example, Dr. Orr noted the defendant commented that he had a lot of fun completing a cognitive test, or abrupt responses, inconsistent understanding, acknowledgement of humor, and occasional intense gaze. She noted that he had poor reciprocity of interaction, including very frequent refocus of conversation back on his own experiences or unusual responses to my sharing. She also noted his lack of close friends and his poor insight into his role in relationships. Dr. Orr further observed deficits in defendant's nonverbal communications, noting poor integration of verbalization and eye contact, limited use of descriptive gestures, restricted range or affect. And then footnote number 6, Dr. Orr noted defendant's social smiling was inconsistent and occurred in unusual and incongruent contexts. She also noted he did not display tearfulness, anxiety, or anger, and an atypical tone. As to his speech, Dr. Orr observed the defendant was generally clearly articulated and his speech was appropriate in rate and volume, but overall monotone. His language generally appropriate in context and form with an extensive vocabulary, but overly formal, often overly inclusive and disorganized, and highly repetitive with frequent scripted phrases. By way of example, Dr. Orr noted that defendant often uses phrases objectively speaking, mind you, to be fair, and moral of the story. As to the second criterion, Dr. Orr found defendant exhibited all four of the behaviors. He engaged in occasional subtle rocking of his upper torso while seated and scripted and repetitive language. He appeared fixated on the routine of timing of breaks and procedures during the examination. He also demonstrated rigidity in his thinking and behavior, persevered ideation, wanting to know the results of his testing, and highly interested in circumscribed topics such as forensic psychology, intellectual topics, and Murakami. She also noted he was highly distracted by sounds or activity occurring around him and frequently looked from side to side to monitor his periphery. As a result of being easily distracted, he needed instructions repeated to him. Defendant's neuropsychological profile revealed a high average intellect at baseline, and his full-scale IQ score was 119, which is in the 90th percentile for his age. Cognitively, defendant showed strong verbal abilities, abstract reasoning memory, concept formation, and reading skills. However, he displayed weakness in executive functioning such as planning, cognitive flexibility, impulse control, and organizational approach. He tended to perceive information in a piecemeal manner rather than looking at the whole picture. Ultimately, Dr. Orr found defendant was clearly a neurodivergent individual manifesting all the social and behavioral features of ASD. As noted, defendant was assigned a level 1 diagnosis without intellectual impairment, which is the least severe level. Dr. Eileen Ryan, a board-certified psychiatrist retained by the defense team, agreed with Dr. Orr's ASD diagnosis after conducting a comprehensive forensic psychiatric examination of the defendant. Of note, she observed that defendant is highly intelligent and has a factual understanding of the proceedings against him, the penalty he is possibly facing, pleas, and the rule of the courtroom personnel. She further noted that there was no evidence of formal thought disorder or thought disorganization. Analysis. Relying on the 5th, 6th, 8th, and 14th Amendments to the United States Constitution and Article 1, Section 1, 2, 6, 7, and 13 of the Idaho Constitution. Footnote number 7. While defendant cites the Idaho Constitution as a basis for his motion, he has not provided any argument or authority as to why the Idaho Constitution should apply any broader than similar provisions in the United States Constitution. Defendant seeks to have individuals diagnosed with ASD categorically exempt from the death penalty. He contends a categorical exemption is warranted for individuals with ASD because 1, they are insufficiently culpable and execution would not satisfy the retributive and deterrent purposes of capital punishment. 2, execution of individuals with ASD is contrary to the evolving standard of decency. And 3, death sentences for individuals with ASD are inherently unreliable due to their inability to present meaningful mitigation evidence. Alternatively, he argues removal of the death penalty as a sentencing option in this case is warranted due to the impact his ASD will have on his ability to present a meaningful defense, particularly given the intense media attention on his disability. A categorical exemption from capital punishment for individuals with ASD is not warranted. The 8th Amendment provides excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. United States Constitution, Amendment 8. The United States Supreme Court has interpreted the 8th Amendment to categorically prohibit the execution of 3 classes of individuals. 1, the intellectually disabled under Atkins v. Virginia, 2002, individuals who commit murder while before the age of 18 under Roper v. Simmons, and individuals incompetent to be executed under Ford v. Wainwright, 1986. At issue here is the first category. In Atkins, the court held the mentally retarded, now intellectually disabled, must be categorically exempt from execution after finding that the cognitive and behavioral deficiencies that drive an intellectual disability diagnosis negate the penological purposes served by the death penalty and give rise to a special risk that the death penalty will wrongfully imposed. In addition, the court found that a categorical exemption was consistent with society's contemporary standards of decency. No court has ever found ASD to be categorically death disqualifying diagnosis. However, defendant argues ASD is the functional equivalent of an intellectual disability, and therefore the rational underpinning Atkins applies with equal force to individuals with ASD. He further argues that the categorically excluding individuals with ASD from capital punishment is consistent with society's prevailing standards of decency. The state responds that a categorical exemption from the death penalty is only available under the law of those with intellectual disabilities, the definition of which ASD fails to satisfy. Further disputes that there is any national consensus supporting defendant's claim. The state is correct. First, intellectual impairment, a hallmark of an intellectual disability, is not present in the diagnosis criteria of ASD, and no court has ever found the two to be equivalent. Second, defendant has not presented any evidence of a national consensus as to whether the death penalty is a disproportionate punishment for individuals with ASD. Next, ASD is not equivalent to an intellectual disability for purposes of the death penalty exemption. Capital punishment must be limited to those offenders who commit a narrow category of the most serious crimes and whose extreme culpability makes the most deserving of execution. In considering whether intellectually disabled persons are categorically less culpable than the average criminal, the Atkins court relied on clinical definitions of an intellectually disabled offered by the American Association of Mental Retardation and the American Psychiatric Association. Both defined the condition based on the presence of two criteria. 1. Sub-average intellectual function, and 2. Significant limitations in adaptive skill manifesting prior to the age of 18. Based on this criteria, the court found the intellectual disabled were categorically less culpable for their crimes, noting clinical definitions of mental retardation require not only sub-average intellectual functioning, but also significant limitations in adaptive skills such as communication, self-care, and self-direction that became manifest before the age of 18. Mentally retarded persons frequently know the difference between right and wrong and are competent to stand trial. Because of their impairments, however, by definition, they have diminished capacities to understand and process information, to communicate, to abstract from mistakes and learn from experiences, to engage in logical reasoning, to control impulses, and to understand the reaction of others. There's no evidence that they are more likely to engage in criminal conduct than others, but there is abundant evidence that they often act on impulse rather than pursuant to a premeditated plan, and that in group settings, they are followers rather than leaders. I have to rest my talking. Based on these deficiencies, the court found two independent reasons to categorically exclude the intellectually disabled from the death penalty, both of which the court found were consistent with the legislative consensus that the mentally retarded should be categorically excluded from execution. First, the reduced culpability of the intellectually disabled undermined the twin justification underpinning the death penalty, retribution and deterrence of capital crimes. As to retribution, the court reasoned that if the culpability of the average murderer is insufficient to justify the imposition of death, the lesser culpability of the mentally retarded offender surely does not merit that form of retribution. As to deterrence, the court reasoned that the same cognitive and behavioral impairments that render mentally disabled offenders less culpable also render them less likely to appreciate the consequences of their conduct and control their behavior. Second, the court found that the reduced capability of intellectually disabled offenders gave risk to an unacceptable risk that the death penalty could not reliably be imposed. Namely, the court found that in the aggregate, intellectually disabled offenders faced a special risk of wrongful execution because 1, they are more susceptible to false confessions, 2, less able to make persuasive showings of mitigation in the face of prosecutorial evidence of one or more of the aggravating factors, 3, may be less capable to give meaningful assistance to their counsel, 4, are typically poor witnesses, and 5, their demeanor may create an unwarranted impression of lack of remorse for their crimes. Further, the court found that reliance on mental retardation as a mitigating factor can be a two-edged sword that may enhance the likelihood that the aggravating factors of future dangerousness will be found by the jury. Relying on the diagnostic criteria set forth in the DSM-4, various publications, and Dr. Orr's evaluation report, defendant argues that individuals with ASD, himself included, exhibit similar adaptive impairments to those with intellectual disability, and consequently the same justification underlying the Atkins exemption should apply to the defendants with ASD. This is an apple to orange comparison, however. While intellectually disabled and ASD individuals often share some of the same adaptive impairments, the intellectual deficit as essential feature of an intellectual disability is not a diagnostic element of ASD. As noted in Atkins, an intellectual disability is based on deficits in both intellectual function and adaptive function. The court then gives a cite to Hall v. Florida, which is the Supreme Court case, noting that the defining characteristics of intellectual disability in the medical community is the existence of concurrent deficits in intellectual and adaptive functioning. While Atkins did not set out a comprehensive definition of an intellectual deficit, it did provide guidance, noting that prevailing medical authorities require significantly sub-average intellectual functioning. To this end, the court noted that the medical community typically considered the cutoff IQ score of the intellectual functioning prong of the mental retardation definition to be between 70 and 75. Under Atkins and its progeny, it is the intersection of intellectual and adaptive deficits that render an individual with an intellectual disability less morally culpable for purposes of the death penalty qualification. As recognized by the Idaho Supreme Court, adaptive deficits alone will not render a defendant mentally incapacitated for purposes of exemption. Footnote 9. As authorized by Atkins, Idaho prohibits the execution of mentally disabled through Idaho Code, Section 19-2515A. That statute defines mentally retarded as significantly sub-average general intellectual functioning that is accompanied by significant limitations in adaptive functioning in at least two of the following skill areas: communication, self-care, home living, social or interpersonal skills, use of community resources, self-direction, functional academic skills, work, leisure, health, and safety. The onset of significant sub-average general intelligence functioning and significant limitations in adaptive functioning must occur before the ages of 18 years of age. The statute further defines significant sub-average general intellectual functioning as an intelligent quotient of 70 or below. The court goes on and says substantial intellectual deficits are required. Intellectual deficiencies, however, is not among the diagnosis criteria for ASD. See the DSM-5. While individuals with ASD may share some of the same adaptive deficits as those with an Atkins qualifying intellectual disability, the essential feature, i.e., intellectual disability, is lacking. That is not to say that individuals with ASD cannot also suffer from intellectual deficiencies. Indeed, Dr. Ryan noted in her report that it is estimated that 50% of individuals with ASD have a degree of intellectual disability. However, it is not necessary to a diagnosis of ASD and therefore cannot be equated to mental disability for the purposes of Atkins. In fact, in United States v. Roof, the Fourth Circuit declined to apply Atkins to a defendant with ASD who had an IQ of 125, noting that his limitations in adaptive skills alone are insufficient to render him intellectually disabled. Within the IQ of 119, defendant likewise fails to qualify. Further, even if adaptive deficits alone could give rise to a categorical exemption, defendant has presented no authority that the adaptive deficits of ASD have the equivalent effect or on culpability or on the ability to make a pervasive showing of mitigation and does an intellectual disability. He dedicates a large portion of his briefing to describing how individuals with ASD, like those who are intellectually disabled, struggle to prevent meaningful mitigation evidence due to their adaptive deficits. He contends they are less able to meaningfully assist counsel due to social and communication deficits and their tendency to focus on specifics rather than the whole picture. He argues that the flat affect and other physical manifestations of ASD can create an unwarranted impression of lack of remorse and further awkward speech and distractibility, render individuals with ASD poor witnesses. He also contends that the evidence of ASD is double-edged because it will likely be perceived by the jury as aggravating rather than mitigation. However, to even be considered for categorical exemption from the death penalty based upon those adaptive impairments alone, defendant would, at a minimum, have to demonstrate that, considered as a whole, individuals with ASD suffer from the same or similar impairments that render them more susceptible to false confessions and diminish their ability to assist the defense. Atkins, 536 U.S. at 320, noting that intellectual disabled individuals in the aggregate face a special risk of wrongful execution due to their deficits. As defendant authorities point out, however, the presentation and symptomology of ASD vary widely. Indeed, as its name implies, it is on a spectrum. Some may suffer from adaptive deficiencies to a degree where it interferes with the presentation of mitigation evidence, and some may not. Footnote 10. Indeed, defendant is an example of a highly functioning individual with ASD. His diagnosis is not accompanied by an intellectual or language impairment. He has an IQ of 119 and graduated from his master's program with a 4.0 GPA. At the time of the homicides, he was enrolled in a doctoral program. His experts describe him as highly intelligent, having a strong verbal abilities, abstract reasoning, memory concept formation, and reading skills. They noted no evidence of a formal thought disorder or thought disorganization. He understands the proceedings against him and the penalty he is possibly facing. He is generally clearly articulated and demonstrated some typical social behaviors such as fairly consistent, though intense, eye contact, polite demeanor, and social conventions. There is no indication he is susceptible to a false confession, nor is there any approaching a confession in this case, to the court's understanding. In fact, Dr. Ryan notes the defendant continues to adhere rigidly to the belief that he will be found not guilty. While he is noted to have a flat affect and other physical mannerisms that can potentially be interpreted by the jury as a lack of remorse, Atkins demands more of a reduced capacity than this. Further, any danger that the jury will interpret his affect or lack of remorse can be mitigated by addressing ASD and voir dire and through expert testimony and evidence in the penalty phase. The lack of any uniform presentation, which can be measured on an objective scale like IQ, youth, and competency, renders ASD inept for categorical exemption. Further, courts have considered whether to extend Atkins to mental health disorders similar to ASD, have uniformly declined to do so. For example, fetal alcohol spectrum disorder, which is a group of conditions that can occur in a person exposed to alcohol before birth, is characterized by many of the same behavioral issues and learning challenges that mark an ASD diagnosis. Reasoning that FASD cannot be medically equated to an intellectual disability, courts have found that the justification for exempting individuals with intellectual disabilities from the death penalty do not apply to individuals with FASD. But note number 12, there is no authority holding that individuals with FASD are exempt from capital punishment, and there's no authority that individuals with ASD are exempt from capital punishment. Likewise, courts including the Idaho Supreme Court have squarely refused to extend Atkins to severe mental illness such as schizophrenia, bipolar disorders, antisocial personality disorders. If courts are uniformly unwilling to extend Atkins to severe mental illnesses, which can be at least equally as adaptively debilitating as ASD, an extension for ASD is unavailing. In sum, defendant has not demonstrated, nor has any court held, that persons with ASD have similar cognitive and behavioral deficiencies that result in an equivalent diminishment of culpability, ability to be deterred, and capacity to assist in their defense as individuals with an intellectual disability. While they may share some similar adaptive deficiencies, defendant has not demonstrated how this alone establishes equivalence for Eighth Amendment purposes. Next, defendant has not established a national consensus against execution of individuals with ASD. For Eighth Amendment purposes, cruel and unusual punishment is defined by evolving standards of decency that mark the progress of maturing society. Ascertaining the standards of decency require considerations of objective indicia of society standards as expressed in legislative enactment and state practice to determine whether there is a national consensus against the sentencing practice at issue. In Atkins, for example, the court found two independent reasons for categorically excluding the intellectually disabled from the death penalty were consistent with the legislative consensus that the mentally retarded should be categorically excluded from execution. Footnote 13. At oral argument, the defendant suggested that if the court found the individual with ASD were categorically exempt from the death penalty based upon the unreliability rationale of Atkins, it need not consider whether the national consensus supported exemption. This is an incorrect reading of Atkins, which is no uncertain terms found that a national consensus supported exemption for both rationale articulated by the court. In light of these deficiencies, our death penalty jurisprudence provides two reasons consistent with the legislative consensus and the mentally retarded should be categorically excluded from execution. Therefore, the defendant must establish a national consensus against execution of ASD, regardless of whether exemption is warranted under the unreliability rationale or the retribution deterrence rationale in Atkins. Defendant argues categorically excluding individuals from ASD from capital punishment is consistent with society's prevailing standards of decency. He notes that the psychological community's understanding of the manifestations of ASD has significantly evolved over the past 40 years, bringing with it marked explosions in both ASD diagnosis and increased societal awareness. Footnote 14. He notes that ASD is now the fastest growing developmental disability in the United States, with a significant increase in diagnosis in both adults and children between 2011 and 2022. He points out that this growing awareness of ASD has coincided with efforts by the criminal legal system to address mental health disorders through the creation of mental health courts. He further notes that evidence of ASD has been held irrelevant in criminal cases to issues of intent. As for legislative enactment, he points to two states, Ohio and Kentucky, which recently enacted legislation barring people with serious mental illnesses from being sentenced to death. At best, this evidence demonstrates a growing societal sensitivity to mental disorders generally. However, evidence of evolving standards of decency must come from legislative and executive action. Two states protecting individuals with severe mental illness from execution is not a national consensus. Further, these two states' statutes only apply to schizophrenia disorder, bipolar disorder, and delusional disorder. Moreover, courts included in the Idaho Supreme Court continue to reject the notion of a national consensus in the context of mental illness. Perhaps recognizing the lack of legislative acts in support of his argument, defendant attempts to show national consensus against executing individuals with ASD through a handful of court decisions finding the diagnosis to be of evidentiary value. None of these, however, are capital cases. He also cites to recent media attention on a Texas capital case against Robert Robertson, an autistic man who was convicted of killing his baby on a theory of shaken baby syndrome. Mr. Robertson is seeking to commute his death sentence based in part on the argument that his ASD contributed to his conviction. Petition for commutation of death sentence to a lesser penalty, or in the alternative, a 180-day reprieve and request for an interview and hearing on the matter. Defendant notes that a group of 84 Texas legislators recommended clemency for Mr. Robertson. However, that defendant fails to mention in these legislators did not recommend clemency due to his autism, but because of significant scientific and medical evidence now shows that his daughter, Nikki, who was chronically ill, died of a combination of natural and accidental causes, not the debunked shaken baby syndrome hypothesis the state used to convict him. In sum, not only has defendant failed to show that ASD is equivalent to an intellectual disability for death penalty exemption purposes, he has not shown there is a national consensus against subjecting individuals with ASD to capital punishment. ASD may be a mitigating factor to be weighed against the aggravating factors in determining if a defendant should receive the death penalty, but it is not the death penalty qualifier. Case-specific factors do not warrant defendant's exemption from capital punishment. Defendant alternatively argues he should be exempt from the death penalty because the intense media scrutiny on his ASD undermines his ability to present a meaningful defense and renders it impossible for him to receive a fair, individualized sentencing determination. He points out that news sources have focused on his social deficits, including his past interactions with females, his deadpan look, robo-like walk, cold iciness, rigid posture, and lack of facial affect. He argues the media is demonizing him for his disability, while at the same time emphasizing the brutality of the crime. This, he warns, will overpower any mitigating arguments based on ASD and poses a risk that he will be sentenced based upon his disability. As the state points out, however, there is no precedent for striking the death penalty due to media coverage. Further, any concerns that arise from such media coverage can be mitigated through voir dire and expert testimony and evidence during the penalty phase of the trial. Order: based upon the foregoing, the defendant's motion to strike the death penalty of autism spectrum disorder is denied. Once again, I think the court made the correct ruling under the law. You may disagree with it morally as it relates to the death penalty, but the bottom line is you have to be, we're not going to sentence somebody to death unless, if they're a minor. If they are, to use the United States Supreme Court's terminology, retarded, not my word. I know some people are offended by that, but that's the law from the United States Supreme Court. You have to show such a mental deficiency that you can't comprehend really what's going on. Clearly, Bryan Kohberger, with an IQ of 119, he doesn't meet that mental deficiency criteria. Next, the order on defendant's motion in limine regarding vague and undisclosed expert testimony. Defendant moves to limit or exclude several different experts disclosed by the state on the grounds that their disclosures are deficient in some regard. Footnote 1, defendant challenges Riley Nolan's expert disclosures, and that was addressed in the order on defendant's motion in limine regarding Riley Nolan and touch DNA contact. Defendant's challenges to David Middleman's disclosure is rendered moot by the parties' agreement to not disclose the IgG evidence. The state responds that it has complied with all discovery obligations and its disclosures are sufficient. It adds that several of the defendant's challenges are fodder for cross-examination, not exclusion. Oral argument on this was held on April 9th of 2025, and after which the court took the matter under advisement. The court finds no basis to exclude or limit the disclosed expert testimony at this time. But if defendant believes that an expert is testifying at trial outside the scope of his or her disclosure, he may object at that time, and the court will consider it. Legal standard: a trial court's decision regarding discovery violations must be supported by substantial and competent evidence in the record. Choice of sanctions for failure to comply with discovery obligations, or whether to impose a sanction at all, is completely discretionary. On discretionary matters, the trial court must 1. Correctly perceive the issue as one of discretion. 2. Act within the outer boundaries of its discretion. 3. Act consistently with the legal standards applicable to the specific choices available to it. And 4. Reach its decision to exercise reason. Analysis. Rule 16b-7 requires the state to provide, upon written request of the defendant, a written summary or report of any testimony that the state intends to introduce at trial that qualifies as an expert witness under Rules of Evidence 702, 703, or 705. The disclosure must include a summary of the witness's opinion, the facts and data for those opinions, and the witness's qualifications. Idaho Criminal Rule 16b-6-7. When a defendant fails to comply with the discovery, the trial court may impose sanctions, including, in appropriate circumstances, the exclusion of a witness. A. Jenny Ayers. Footnote: the state submitted 3 disclosures for Ms. Ayers. The initial disclosures, December 18th of 2024, the rebuttal disclosures, February 17th of 2025, and the amended supplemental disclosures, March 3rd, 2025. Jenny Ayers is a forensic scientist with the Idaho State Police Forensic Services who works in evidence collection and crime scene processing. She is disclosed to testify in the state's case in chief about crime scene processing generally, including collecting DNA, blood stains, latent fingerprints, hair, and fiber and shoe impressions. She will explain what DNA is, that it may be present in biological materials or left on an item when handled, and that it is collected or for preservation and sent elsewhere for testing. She is also going to testify to her work in this case detailed in Lab Report 25 and supporting field notes. The report discusses the Idaho State Police's processing of defendant Pullman's apartment and the Washington State University office, which included photographing and collecting evidence. Miss Ayers was specifically involved in capturing images of the apartment and the office and performing presumptive tests for the presence of blood at various points in the apartment. Her rebuttal testimony concerns ISP's crime scene investigation procedure generally and the ISP's forensic team's processing of the crime scene at 1122 King Road, including identifying areas that contain probative evidence. In addition, the lab report 11, and field notes for the team's work as referenced by Bates within the disclosure. Defendant argues Miss Ayers' case-in-chief disclosures do not provide any opinion she has about the crime scene processing or about the DNA at issue in this case. Thus, he asks the court to limit her testimony to her qualifying background and her work in Lab Report 25 as to her rebuttal disclosures. Defendant argues again that it fails to provide any opinion about crime scene investigation procedures, and it does not clearly state what she is processing 1122 King Road and what her opinions regarding that work. Defendant's challenges misapprehend the type of expert Miss Ayers is. Much like law enforcement, Miss Ayers is a hybrid fact expert witness as opposed to traditional expert. She will be educating the jury on crime scene investigation procedure to provide foundation for her testimony regarding the work she and her team performed in this case as outlined in the lab reports 25 and 11 and the accompanying field notes. This testimony is factual in nature, despite the fact it requires special knowledge, skill, experience, and training. Consequently, the absence of the opinions in her disclosure does not limit her ability to testify to these matters. In addition, Ms. Ayers' rebuttal disclosure is replete with explanations about why and how the crime scene investigation was carried out at 1122 King Road. Her testimony will be allowed as disclosed. Footnote number 3. For example, the disclosure discusses why the team focused on certain areas of the home as opposed to others, why they decided to not collect mattresses and bed frames, and why they swabbed and or applied Amido Black where they did. Special Agent Nicholas Balance. Footnote number 4. The state submitted 3 disclosures for Mr. Balance. Initial disclosures, December 18th of 2024. The rebuttal disclosures, February 17th of 2025. And the amended supplemental disclosures of March 3rd, 2025. In addition, throughout this case, defense has had and been on notice that the Exhibit A to the various search warrant affidavits will detail much of the opinion and analysis of the CAST team and thus Balance, including those related to defendants' locations as outlined in the times before the homicide. So once again, FBI Special Agent Balance was primarily involved in the analysis of cell phone records in the investigation. He is disclosed to testify in the state's case in chief about the analysis of AT&T cell phone records for the defendant, Madison Mogan and Zaina Knodel, as well as his own drive testing measurements to determine the use and general location of their cell phones between June of 2022 and November of 2022. Accompanying his initial disclosure is his 30-page CAST report, which discusses the maps and data he reviewed, the methodology employed. His supplemental disclosure goes through each page of the CAST report to discuss its significance. He will also discuss topics pertaining to how cellular technology works, particularly how cell towers operate and how cell phones connect to the towers, how cell phones usage data is reflected in call data records, and how those records provided by AT&T for the target cell phones in this case were used to create the cell site maps showing their general locations before and after the homicides and their direction of travel. In challenging Agent Balance case-in-chief disclosures, defendant provides the affidavit of his cell phone data expert, Cy Ray. Mr. Ray complains that he is unable to identify Agent Balance's methodology, which was described in the CAST report. Mr. Ray states that the CAST report omits data and or fails to mention how certain AT&T data was utilized in his analysis, namely hand-off data and drive test mapping, and why some data was ignored. Footnote 5. Mr. Ray notes that Agent Balance failed to include an analysis of the handoff data for defendant's cell phone between the hours of 2:30 and 3 a.m. on November 13th of 2022, that he did not include the mapping he relied upon to establish defendant was near the crime scene on several occasions before the crime, and he failed to disclose how his driving testing works to a sufficient degree. He asserts this omitted data and methodology is exculpatory, and without it, he cannot fairly analyze Agent Balance's work. According to the state, its disclosures sufficiently identify Agent Balance's opinions and the facts and data he relied upon, and defendant's concerns are fodder for cross-examination. In fact, in Agent Balance rebuttal disclosure, the state marches through each concern outlined by Mr. Ray, offering additional explanation about what Agent Balance considered, including the handoff data and why. The defendant, however, asserts the attempted clarification in the rebuttal disclosure is insufficient, arguing there is no disclosure as to why he was admitted 95% of the relevant coverage maps for his drive testing, no analysis of mapping of the handoff data, and no documentation provided by the CASH report peer review process. Footnote number 6. There's no requirement under Rule 16, Idaho criminal rules, that the state provide peer review documentation of an expert's report. Likewise, the rule does not require an expert to identify the data they did not rely upon or why they did not rely upon that data. However, the fact remains that the defendant has all the facts and data that Agent Balance relied upon to form his opinion, which are expressed under the CASH report. Number 7, footnote 7, a draft of the CAST report was disclosed to the defense in the early stages of the case. It was subsequently peer-reviewed, and the final CAST report was issued and disclosed on July of 2024. The data supporting Special Agent Balance's opinion is located in the files of the cell phone records provided by AT&T and the test drive files, which were provided to defense through discovery. Supplemental disclosure, page 2, identifying disclosed information relied upon by Agent Balance by descriptive, AV number, and date disclosed. While his methodology might not be set forth with much specificity as Mr. Ray would like, Rule 16 does not require the detailed methodology be provided. It requires merely opinions, facts, and data for those opinions and the witness's qualifications. To the extent the defendant believes Agent Balance omitted important data or is relying on insufficient data for this opinion, this is fodder for cross-examination, not exclusion. Moreover, if an opinion is not reasonably set forth within the disclosure, it will not be allowed. Footnote number 8. For example, defendants complained at the hearing that Agent Balance analyzed handoff data for the 7 minutes prior to the phone powering off at 2:54 a.m. on November 13th, 2022, but did not provide an opinion about what his analysis showed. Thus, defendant wants to exclude any opinion as to what his analysis of those 7 minutes showed. However, as pointed out in Agent Balance's rebuttal disclosure, page 13 of the CASH report sets forth the data Agent Balance relied upon to opine that defendant's phone used a certain tower and sector at 2:47 a.m. southeast of his apartment and ceased communications with the network at 2:54. He also explains that the location of a device is best estimated by the initial cell site versus the handoff cell site. He will be allowed to testify to these opinions. If defendant believes Agent Balance strays beyond these opinions, he can object and the court will take the matter up then. Next, Heather and Jared Barnhart, footnote number 9. The state submitted the following disclosures for the Barnharts. Their initial disclosure, Heather Barnhart. Initial disclosure, Jared Barnhart, December 18th of 2024. Rebuttal disclosures, Heather and Jared, February 17th of 2025. Their rebuttal disclosures state simply that the Barnharts intend to rebut the expert testimony of Carol Pendon, Kevin Pendon, and Josiah Roloff, but need additional information prior to offering rebuttal opinions. Defendant is not challenging these. The Barnharts are digital specialists with Cellebrite who were retained by law enforcement to analyze defendant's cell phone and PC to determine user behavior and actions. They are disclosed to opine that the gaps in data on the two devices were abnormal. Footnote number 10. Specifically, their report explains that the gaps in data may be consistent with cleaning up or using anti-forensic methods to clear evidence. Attached to the disclosures is a report jointly authorized by the Barnharts detailing their analysis and their findings. Their CVs were provided as well. Defendant argues that the disclosures indicate they will testify to habit evidence, which he complains is not explained and is not accompanied by an opinion. Defendant challenges is confusing. Nowhere do the disclosures or the report indicate Barnharts will testify about habit evidence. Rather, the disclosures state they will testify to their findings pertaining to defendant's activities on his PC and cell phone for a period of time before and after the homicides and why gaps in data over the time period are abnormal. The Barnhart's opinion regarding these topics are fully set forth in their joint report. For example, they observe gaps in defendant's school PC that may be consistent with cleaning up or using anti-forensic methods to clear evidence. Among the gaps found were in the PC event logs and systems resource usage monitoring between November 11th and November 16th, 2022, which Barnhart opined was abnormal given school was in session. Likewise, they located gaps in the PC's Chrome history during dates where downloads occurred on the system, indicating the user was private browsing or clearing browsing history. Together, the Barnhart's disclosures and joint report set forth that are required under the Rule 16b-7, and there's no basis to exclude their testimony. Michael Douglas, footnote 11. The state submitted 2 disclosures for Mr. Douglas, the initial disclosure on December 18th of 2024 and their supplemental disclosure on March 14th of 2025. Mr. Douglas is a forensic accountant for the FBI and is disclosed to testify to financial transactions for defendant, the 4 victims, and the 2 other roommates. His initial disclosures identifies by category and date range the financial transaction data he intends to testify and to appends Mr. Douglas reports to specific transactions found within these individuals' financial data. His supplemental disclosure identifies more specifically the financial data associated with the defendant that he intends to discuss and also identifies video evidence obtained showing defendant's ATM withdrawals. Defendant contends that Mr. Douglas should not be able to offer an opinion because none are expressed in his disclosures. Specifically, defendant notes that Mr. Douglas's supplemental disclosure indicates he will testify to an analysis of defendant's spending habits. Defendant takes issues with this, arguing there is no spending habit opinion disclosed. However, Mr. Douglas's disclosure makes clear that he is intended as a fact witness and is only being disclosed as an expert in the event the court determines his testimony was based upon specialized knowledge under Rule 702. Moreover, although the supplemental disclosure appears to indicate he will offer an opinion as to defendant's spending habits and his testimony will be limited to factual changes in how defendant spent money, for example, the disclosure notes defendant only conducted ATM withdrawals on or after the date of the homicide and ceased using his debit card after November 10th of 2022, whereas prior to November 10th, he had regularly used his debit card. There is no indication he will attempt to opine about the reasons for the spending change, just that they occurred. Footnote number 12. Without more, the court has concerns about the relevance of his testimony, but defendant has not challenged it on that basis as of yet. Thus, there's no basis for excluding or limiting Mr. Douglas's testimony based upon disclosure concerns. Shane Cox. Footnote 13. The state submitted 2 disclosures for Mr. Cox, December 18th of 2024 and March 3rd of 2025. Mr. Cox is a litigation and regulatory manager for Amazon.com. His initial disclosures state Mr. Cox will testify to the context of the documents produced by Amazon to law enforcement pertaining to an Amazon account associated with the defendant. The documents include the order history between January 5th of 2022 and December 13th of 2022, and the click history and the sign-in history for the specific dates in that time frame. The documents are referenced by Bates number. His supplemental disclosures identify with specificity the facts that Mr. Cox will be testifying to the identified documents. As with this challenge, Mr. Douglas, defendant, asserts that Mr. Cox should not be able to offer any opinions because none are expressed in his disclosures. 14. The defendant also asserts in that motion that Mr. Cox's testimony should not be allowed because, according to the defense expert, David Howell, far more information must be reviewed in order to attribute specific activity to a specific person or otherwise render an opinion about users' behavior and forensic certainty. This argument was addressed and rejected by the court in its order memorializing oral rulings on motions in limine on April 18th of 2025. Again, Mr. Cox is a fact witness and will not be offering opinions on the documents apart from explaining what the documents show as outlined in his disclosures. There's no basis for exclusion. Darren Gilbertson. Footnote 15, the state submitted a rebuttal disclosure of Detective Gilbertson on February 17th, 2025. Defendant disclosed expert opinion by Brent Turvey that more than one assailant was necessary to accomplish the crime in the time frame alleged. Specifically, he asserts, 1, there is direct and indirect evidence that attempts were made by the suspects to clean up the crime scene after the homicides, which would have taken far longer than the time interval alleged by the state. And 2, there were multiple weapons used against Kaylee Gonzalez, and Zena and Ethan appeared to have been attacked at the same time. This is the Turvey report, page 20. Through his other experts, Rachel Orr, defendant has submitted evidence that he suffers from developmental coordination disorder, which has resulted in deficits in fine motor dexterity and visual motor function. His attorneys have argued in other motions that these deficits render it not possible for Mr. Kohberger to have acted with the speed and coordination required to commit the crimes in the time frame alleged by the state. However, this has not been disclosed as an opinion of any defendant's experts. In rebuttal, the state disclosed Detective Darren Gilbertson, a lead investigator for ISP in this case. The disclosure indicates he will testify that he and other investigators conduct timed runs at 1122 King Road to gain an understanding of the approximate time needed to have carried out the homicides. A report of the time runs is attached in his disclosures. It was performed to determine if one person could carry out the homicides. His opinion will be that depending on the suspect's pace and routine, he could have carried out the crimes in approximately 2 to 4 minutes. Defendant argues Detective Gilbertson's testimony should be excluded because 1, the state has failed to disclose how Detective Gilbertson is an expert in timed runs. 2, the relevance is minimal. 3, important data, i.e. recordings, photos, and notes of the experiment, was not disclosed. And 4, his opinion carries a risk of juror confusion and prejudice. On the prejudice issue, defendant claims that Detective Gilbertson was already familiar with the house when he did the experiment, and additionally, the house has been vacated. Defendant also notes that the house has been torn down, so he is not able to conduct his own tests. Whether Detective Gilbertson's opinions are relevant will depend on what Mr. Turvey and Dr. Orr opine at trial. Footnote 16. The court has indicated in a separate order that there is no foundation at this point for a defendant's assertion that his deficits in fine motor dexterity and visual motor function rendered it difficult or impossible for him to commit the crime. See the order on state's motion in limine, dated April 18th of 2025. While Dr. Turvey does not specifically state in his report that one assailant could not have accomplished the murders in the short time frame alleged by the state, he infers as much through his opinion that there was evidence of cleanup efforts at the crime scene which would have taken a significant longer period of time. Further, while Dr. Orr reports do not opine as to what deficits in fine motor dexterity and visual motor function defendant suffers from, to the extent she testifies to these at trial, it may render Detective Gilbertson's opinions relevant to rebut any inference that the defendant could not have single-handedly committed the crimes in less than 15 minutes. Further, given Detective Gilbertson's role as the lead detective for ISP in the investigation, he is well qualified to offer his opinion on suspected movement throughout a crime scene. In addition, there does not appear to be a disclosure violation due to the lack of the underlying data. It was a simple experiment consisting of timing Detective Gilbertson moving through the house at a slower speed and a faster speed. His routes were described, as well as his pauses to simulate the number of stab wounds each autopsy showed. It does not appear there are any photographs or recordings or any other data not already described therein. As for defendant's 403 concerns, they are baseless. The state represents that there were no structural changes to the house when Detective Gilbertson performed his experiments. The fact that it was vacated, or that Detective Gilbertson was familiar with the home, which would presumably allow him to conduct a faster time run, is fodder for cross-examination, not exclusion. The state further notes the defendant stipulated to the house being torn down after Detective Gilbertson's report was disclosed. Thus, any concern of prejudice in this regard in his own is his own doing. Finally, defendant cites no basis for jury confusion. Consequently, Detective Gilbertson's disclosed testimony will not be excluded at this time. Next, ISP forensic lab scientists. The expert in this category, specifically referenced by defendant, are Kathleen Dacey White, Taylor McKay, Tara Martinez, Jade Miller, Ann Nord, Eric Seat, Tina Wethall, Stephanie Wilt, and Haley Youngling. The analysis herein applies equally to the defendant's challenges raised for the first time in his reply brief to forensic toxicologists from the NMS Labs, Daniel Albertson, dated December 18th of 2024, and Chelsea Deisher, 12/18/2024. The state disclosed several forensic scientists from the ISP forensic lab to testify as experts in this case. The initial disclosure for each scientist describes the subject matter the expert will discuss, including the particular evidence and testing performed. The disclosure also referenced each scientist's specific lab report by Bates number. In each disclosure, the state includes the following caveat. This disclosure is provided as an aid. It does not encompass all findings, impressions, conclusions, or materials related to the expert's involvement in this case. It further does not in any way limit the scope of the expert testimony. Further, this expert may testify about findings, impressions, and/or conclusions that he or she drew from the work from other experts who previously examined or handled the evidence in question. After the defendant moved to compel more complete disclosures, the court advised the state to supplement accordingly. On March 3rd, 2025, the state did so largely by expounding upon the general subject matter of the expert's respective work. Footnote 18. For example, where the initial disclosure stated the expert would testify generally about the collection of DNA, the supplemental disclosures include far more detail about the collection procedure. They did not add any new opinions. Paragraph 19. To the extent that Jade Miller's supplemental disclosure and Kathleen Dace White's rebuttal disclosures contain a discussion of CODIS, how it works, how CODIS eligibility is determined, why the decision was made not to enter certain profiles into the system, defendant objects that it's new. Untimely opinion. However, the court does not view the discussion as an opinion. Rather, it is a purely factual issue explaining reasons why certain decisions were made consistent with CODIS rules and limitations. In addition, to the extent defendant contends these facts were not timely disclosed, defendant has plenty of time between their disclosure and trial to address them. Defendant now moves to limit the scientist's testimony in the state's case in chief that their lab reports limitation is not necessary. If the scientist testifies to something that is not disclosed in their disclosure or lab reports, defendant can object at trial. There is no basis to prospectively limit their testimony now. That's interesting. What do I always say, ladies and gentlemen? They're trying to get rid of the evidence that hurts them, the DNA. They're objecting, trying to come up with anything to keep the DNA out. Next, Dr. Gary Dawson. Footnote 20, the state submitted only a rebuttal disclosure on February 17th of 2025. Dr. Gary Dawson was disclosed in rebuttal by the state to testify to the degree of impairment of the victims, particularly Madison Mogen, at the time of the homicide. His expert report attached to his disclosure opines that Madison Mogen would have been markedly intoxicated from the effects of alcohol around the time of her death. She would not have had the ability to mount a meaningful response to a sudden threat to her person. He further states that while he has limited his review to Madison Mogen, the same general principle applies to the other victims. Defendant seeks to strike his testimony on grounds that it is improper rebuttal. He contends that none of his experts have challenged her ability to fight back or otherwise contested her toxicology levels. The state responds that the opinion rebuts defense expert Brent Turvey's opinion that more than one assailant was necessary to accomplish the crime in the time frame alleged. Specifically, the state argues that evidence Miss Mogen was unable to effectively fight back supports its position that one assailant could have completed the homicides in a short time frame. Rebuttal evidence is evidence which explains, repels, counters, or disproves evidence which has been introduced by or on behalf of the adverse party. Mr. Turvey has opined in his report that two assailants were involved in the homicide, particularly because he believes multiple weapons were used against Kaylee Gonzalez. Inferred in this opinion is that one person would not have had the time or ability to use multiple weapons in the time frame alleged when faced with two victims. If Miss Mogen was intoxicated at the point of being unable to fight back, however, it would be possible for one suspect to incapacitate her, and then use multiple weapons in attacking Miss Gonzalez. However, whether Dr. Dawson's opinion is relevant depends on how Mr. Turvey's testimony unfolds at trial. Consequently, his disclosed rebuttal opinion will not be excluded or limited at this time. Lawrence Mowry, Jeffrey Tenzola, Neil Uhrig. Footnote 21. The disclosures of these individuals are as follows. Initial amended disclosures, amended supplemental disclosures, January 7th of 2025, February 17th of 2025, December 8th of 2024, and March 14th of 2025. Detectives Lowry, Maury, Agent Jeffrey Tenzola, and Detective Neil Uhrig are forensic detectives who are involved in the investigation of this case. Detective Mowry of the Moscow Police Department is disclosed to testify in the state's case in chief as an expert in the field of digital forensics and his role in the investigation. Specifically, he may testify to any of the subjects identified in his reports and may identify and testify to chain of custody, extraction, electronic data, files, and location records identified that the materials are made available to the defendant. There are approximately 50 individual devices, electronic accounts, digital data listed in the disclosure about which he will testify, and he will opine that he found no connection in that material linking defendant to the devices and data that he analyzed. Footnote 22. Because Detective Mowry analyzed devices and information associated with the defendant, presumably these are excluded from his opinion. Jeffrey Tenzola is a special agent with FBI who extracted, processed, and archived the contents of 7 identified digital devices belonging to the defendant. His is disclosed to discuss in the state's case in chief extraction, imaging, examination, processing, verification, transportation, and chain of custody of those devices. The disclosure references and appends his report of examination regarding his work in this regard. Footnote 2023. Defendant is not challenging Detective Uhrig's rebuttal disclosures. Neil Uhrig is a forensic examiner and detective sergeant for the Post Falls Police Department who extracted, processed, and archived a lot of reading. Neil Uhrig is a forensic examiner and detective sergeant for the Post Falls Police Department who extracted, processed, and archived the contents of computers belonging to the victims and 2 other roommates of 1122 King Road. His case-in-chief disclosures likewise state he will discuss extraction, imaging, examination, processing, verification, transportation, and chain of custody as to those computers, including the expertise necessary to extract the data from the devices. He will opine that there was no connection found between the listed devices and the defendant. His initial disclosure reference and appends his office report regarding his work in this regard. The defendant argues that each of these 3 experts' testimony must be limited to what has been disclosed, the devices, data examined, and process used. Other than the disclosed opinions by Detective Mowry and Uhrig that no digital connection was found between the defendant and the residents of 1122 King Road, the defendant argues no specific testimony regarding what the devices and data depicted should be allowed. To this end, defendant notes that the state has not identified in the disclosures the specific portions of the identified devices and the data that the experts will testify to. In response, the state clarifies that it is not seeking to elicit opinions from the witnesses. Rather, it intends to elicit testimony about the qualifications necessary to perform the extractions and analysis of the identified devices and data. It further represents that the defendant has been provided with all the data analyzed. There is no basis to exclude or limit detectives' disclosed testimony. It is clearly they will be testifying to the facts of the investigation, not providing traditional expert opinions. There is no need, therefore, for the detectives to identify specifically what the device and data depict. This is factual in nature, and the defendant has been provided the materials reviewed by the detectives. Next, Robert Hill, or Hill-E, H-I-L-L-E. The state submitted only a rebuttal disclosure on February 17th of 2025. Robert Hill is a special agent with the FBI who reviewed surveillance footage from the hours before and after the homicide occurred, depicting the law enforcement believes is suspect vehicle number 1. Agent Hill was disclosed to rebut opinions by defense expert Stephen Becker that it was not possible to ascertain from the surveillance video whether a front license plate was missing from the vehicle. Agent Hill rebuttal references the full summary of video depicting suspect vehicle 1, which has been disclosed to the defendant. as a basis for his opinion that suspect vehicle 1 did not have a front plate. He then lists the specific camera locations and timestamps he contends show a clear view of the missing front plate. His rebuttal also states he will provide testimony about the significance of the missing front plate. The defendant contends that since Agent Hill is not offered an opinion as to any videos other than those specific clips referenced, his testimony must be limited to those identified clips. However, Agent Hill's disclosed opinion is not restricted to the identified clips. It expressly is based on the full summary of video of suspect vehicle 1, with the identified clips being most clear. Thus, the court will not limit his testimony in this regard. Based upon the foregoing, the defendant's motion in limine regarding vague and undisclosed expert testimony is denied. There you have it, ladies and gentlemen. Disclosure, discovery issues, denied. Strike the death penalty of autism spectrum disorder, or strike the death penalty because of autism spectrum disorder, denied. And then the motion for text messages and the 911 call coming in almost in its entirety. Not unsurprising at all to me. I understand what the defense is trying to do. I would be doing the exact same thing as a defense attorney. Don't get me wrong. I am not criticizing the defense. They're doing exactly what they should be doing, and they're doing well. They're just not winning. But welcome to the world of criminal defense on the defense side. You're not supposed to win. Most of your motions are going to be denied. You're trying to create new law. Most of this stuff is being written for appellate courts, assuming there will be a conviction. So the bottom line is, ladies and gentlemen, the defense is doing a good job, as well as the prosecution as well. They're getting basically everything in that they need. Next, Karen Reed. The Karen Reed trial continues in Massachusetts today, and the jury is expected to hear more witnesses testifying, as also pay a visit to the scene of the alleged crime, 34 Fairview Road in Canton. Now, the jurors are going to be bussed over to the former home of Bryan Albert, where Reed is accused of hitting her Boston police officer boyfriend, John O'Keefe, with her SUV and leaving him to die in the snow back in 2022. They will also see the Lexus that Reed was driving that night. And when they get back to the courthouse, jurors are set to hear from the prosecution witnesses, Dr. Gary Fowler, who is expected to testify about Reed's blood alcohol content on the morning after O'Keefe died. Next, this day in legal history, on April 25th, 1792, highwayman Nicholas Jacques Pelletier became the first person beheaded by the guillotine in France. On April 25th, 1901, New York, leave it to New York, mandates automobile license plates. That's right, it became the first state in the United States to require license plates and, of course, fees. The legal requirement was in response to the growing number of vehicles and the need for regulation and identification. Obviously, it set the precedent for license plates throughout the United States. On this date, in April 25th, legal significance, 1961, patent for the integrated circuit. That's right, in 1961, Robert Noyce was granted a patent for the integrated circuit, obviously a groundbreaking invention that revolutionized electronics. On this date, April 25th, in 2000, Vermont Advanced Civil Unions, that's right, the Vermont House of Representatives, passed a bill allowing civil unions for same-sex couples. This was the landmark movement in the legal recognition of the same-sex relationships in the United States, obviously paving the way for marriage equality and civil rights legislation. On this date, on April 25th, 2018, the United States Supreme Court heard oral arguments in Trump v. Hawaii, a case concerning the legality of President Trump's then travel ban. The case was significant for its implication on executive power, immigration law, and national security, and it highlighted the legal debates over presidential and civil liberties. It's almost like that's come back around again, hasn't it? Presidential power versus the court saying what you can and can't do. Obviously, his travel ban was upheld. And finally today, our dumb criminal of the day. Wait for this, ladies and gentlemen. In the course of a child probe targeting his younger brother, an upstate man caught a case himself when they discovered video showing him engaging in sexual acts with animals, specifically a cow. Mr. Mark Banks, we'll give him the presumption of innocence, was arrested earlier this month for sexual misconduct for allegedly having sexual intercourse with a dairy cow on the property of Windsor Acres up there in Broome County, where he apparently works. Anyway, the New York State Police were investigating, originally focused on Banks' brother, Christopher, for possession of child images, right? Well, when the police executed a search warrant for his residence, which he apparently shares with his brother, they scooped up an assortment of electronic equipment. A review of the seized materials resulted in the filing of felony charges against Christopher for possessing a sexual performance by a child and a school cafeteria employee. Christopher was immediately fired from the local school district. What a coincidence. He just happened to work at the school district and liked children. Anyway, next, in a handwritten statement given to police about his own free will, Mark wrote that the state police found some videos on my devices today involving sex with animals, adding that when I was younger, I had sex with a cow. That was his confession. After describing the cow incident, Mark wrote, I did not ejaculate, but did so because of sexual urge. It didn't work at first, and I shifted the bucket and tried again. This did not happen again after that. Apparently, Mr. Banks didn't know that bestiality is a crime. Anyway, the Banks brothers are due back in court Thursday to answer for the criminal charges. The misdemeanor charge Mark faces carries a maximum of up to 1 year in jail. And if convicted on the child, the brother, Christopher, faces up to 4 years in custody. Upon conviction, each would carry the charge of having to register as a sex offender. I would think the public humiliation of admitting that you had sex with a cow would be sufficient punishment. But hey, you got to keep those cows safe up there in upstate New York, apparently. All right, ladies and gentlemen, that's all we have for today. Hope you enjoyed the show. I know it was a long one, but we want to give you all the facts and all that new information that you have that came from those little footnotes and reading the entire court order. I hope you appreciate it. Thanks for watching. We'll see you next time. And remember, the Constitution matters.